fresh legal twist has emerged and is putting the spotlight once again on the long-running allegations surrounding President Bola Tinubu, with the FBI asking a U.S. court to explain behind closed doors why some records remain secret. The FBI says releasing the records could expose law enforcement techniques and potentially endanger individuals. But the move comes after a 2025 ruling in which Judge Bell Howell ordered the FBI and the DEA to lift their refusal to confirm whether Tinubu had been a subject of criminal investigation. Now, the FBI wants to justify some of its withholding privately under seal. The records dating to the early 1990s are being sought through Freedom of Information Act requests. Tonight, we ask what exactly is being withheld. Joining us live from our Abuja studio for this story is legal practitioner and good governance campaigner Abdulkareem Musa. Abdulkareem, thank you for being here. If you were sitting on that bench, would you grant the FBI's request to explain its reasons for withholding these records privately? Or does that undermine the very principle of transparency of the Freedom of Information law, which is it supposed to protect?
Good evening, Felicity. Thank you for having me. Well, if I was sitting on that bench, the first thing to put to mind is the fact that this is a very sensitive and politically delicate matter. And the records that we are talking about or that is being demanded are records that could have alternative outcome. And so the records could vindicate President Tinubu and put an end to the allegations, the accusation, and political insinuations that is involved in drugs. The record is also capable of causing very serious and reputational embarrassment and damage to not just the individual of Tinubu, but to the entirety of the Nigerian citizens. And so, having that in mind, then you must proceed from the perspective of political transparency, the consideration of legal disclosure, and the right of the other parties to fair hearing in assessing this application that they want to have the record head ex parte. And so if having this against the backdrop of all these points I highlighted, I think as a judge, I would first demand to see the documents because the judge constitutes part of the state. And so the FBI could not lay claim to documents that are in their possession and deny the judge the opportunity of assessing the documents and determining whether these documents are requiring of the secrecy that the FBI are claiming that they do.
But how do you distinguish legitimate national security or personal safety concern from a convenient excuse for withholding what some would describe as embarrassing information?
Yes, it might seem to me like a convenient excuse and an escape. But what the FBI, in my opinion, must bear in mind is that there is an entire sovereign state, a sovereign nation, anticipating the content of this record that is being demanded. Nigerians are not just spectators in this whole controversy. Nigerians are a constituency whose legitimacy, whose mandate give President Tinubu legitimacy to be president of Nigeria. And so it might be a convenient position for the FBI to simply claim that the contents of this document occasion insecurity to some individuals and that the content reveal their security strategies. But the question we must ask, or the FBI, we must put to the FBI, who are these individuals? They should disclose to the judge, who are these individuals that the contents of the record constitute security threats to? What are those security threats and how real are they? When was this investigation conducted and how long would this purported security threat linger? And then the bigger question should be, can a single record or investigation report contain names of persons, contain how these records constitute security challenges to these persons, and that same record contain security strategies that require protection or secrecy? What kind of record is that containing all this information? And assuming there is such a record, are they able to also ensure, because even at the last hearing, they refused to disclose to the court whether or not the president was even a subject, President Tinubu was even a subject of investigation. So do they have a pact? Do they not have a pact with President Tinubu, assuming President Tinubu decides to come out today and say, oh, I was part of the investigation, this was what happened during the investigation? They do not have the authority to enter such a pact. And so it appears to be a convenient disposition to say that records that are very pivotal to the integrity of the Nigerian state are secret because it constitutes threat to certain persons and reveal security strategies. It's a rather convenient position to maintain by the FBI.
Yeah, we need to go on a break, but you mentioned something that previously a judge had ruled that the FBI and DEA had failed to establish a sufficient basis for refusing even to confirm whether Tinubu was a subject of investigation. So go ahead with your response, please.
Yes, thank you. So previously, the FBI had refused to disclose certain information, and when the court asked them to justify their refusal to disclose this information or produce this record, they gave certain reasons, but the judge was not convinced. He said they had not given cogent and cognitive reason enough for them to refuse to produce the records that has been demanded. Now, they have engaged another procedure of law to say, but the reason why they cannot disclose the records, they want to make those reasons known to the court ex parte. It means without the notice of the other parties. And so, in my view, I think this is another way of engaging a procedure to accomplish what you have previously failed to accomplish. You had previously attempted to withhold information or records or documents from the court and the other parties, and the court said your reason for refusing to release the records that was asked of you was not cogent enough. And now they have come to say they want to disclose the reason which they had previously disclosed openly. Now they want to disclose it ex parte. I think that the court should not allow the FBI or any party in the proceeding to engage technicalities in forestalling proceeding. The record should be made open and available to the court. The court has the capacity as an agent of the state to determine whether those records actually constitute threats to any individual, whether those records actually reveal security strategies that would not be good for the state. And like I said, the FBI and all the parties involved must know that this controversy is beyond the FBI, is beyond the United States of America. It extends to the Nigerian citizens, of course, whose mandate give legitimacy to Tinubu's presidency.
One before we go, regardless of the outcome, does any of this have legal consequences for Tinubu's presidency, or is it just strictly perhaps a U.S. Administrative Freedom of Information Act matter?
Well, it has, when you talk about legal, it certainly has political consequences, as it may, in one way or the other, vindicate him or vilify him and give cast aspersion on his political image or integrity. But legal implication, by the Nigerian laws that we have, if a person is convicted for a crime, the person would not be qualified to contest in an election. And so we don't know the extent of the records, and that is why it is important that Nigerians are not left in the dark. The records and the extent of the culpability of President Bola Tinubu would actually impact on his legal capacity to continue to be or